Thank you, Mr. Chairman, members of the committee. When I graduated from the University of Texas School of Law, I went to work for Chief Justice
Give us your name.
Shelby Sharpe.
Thank you.
I'm sorry, I thought I did. Excuse me. When I graduated from the University of Texas School of Law, I went to work for Chief Justice Robert Calvert at the Supreme Court of Texas. And since I left that court, I have handled a lot of constitutional law issues, many times before that court in the Supreme Court of the United States. Some years ago, it was brought to my attention, a lady came to me and said, my husband sued me for divorce. I'm not a family lawyer. She says, well, I think there's something wrong that you can't defend yourself. I said, well, due process has 6 elements, and marriage is a constitutionally protected right. But I looked at it, and the last 2 elements are not there. One, that you can either prove a defense that bars it, or you can prove there's no merit in it. Neither of those is possible. Now, let me explain to you real quickly. No-fault divorce came in 1970. At the time it came in, the divorce rate in the United States was 1.5 and had descended from 3 point something to 1.5. When I grew up, I only knew a couple of kids that their parents were divorced. I only knew a couple of adults that were divorced. But since no-fault divorce came into effect in 1970, and by the way, there's not one single study on no-fault divorce that has found that it was good. Not one. All of them have found these consequences. 1, it has put more women and children in poverty than any other single piece of legislation. 2, it has caused, and by the way, y'all are concerned about the budget? In 1970, in the public schools, there were no remedial courses, period. There were courses for children who were learning disadvantaged and had problems, but since then, the remedial courses have shot through the roof, and guess what? They're populated 100% with kids from a broken home, 100%. So you've increased that. When I went to Fort Worth to practice law, there were 2 family law courts. There's a whole building now of family law courts there, and it dwarfs the civil district courts. So you have exploded that and added that to your budget. So look at the poverty part that you've increased as a result of it. Look at your public schools cost. Now also look at the health costs. The studies are absolutely irrefutable. They've increased those. Look at your crime rate. You can also show empirical studies. So since 1970, when it was 1.5% of families, you've created this problem. Now here is the real interesting thing. The first Supreme Court of Texas, Chief Justice Hemphill, writing an opinion, said if divorce were permitted for little or no reason, here's what would happen to the culture. And he described in explicit detail what we have today. And here's what his final statement was. He said, yes, divorce should happen, but only for reasons, solid reasons approved by law. Because when people know they can't just get a divorce for any reason, they become good husbands and good wives. And from 1848 to 1970, he was right. And from 1970 on, he was right on the consequences. Thank you very much.
Thank you, Mr. Sharpe. Any questions? I think Mr. Sharpe.
Mr. Sharpe.
Mr. Sharpe, if you'll come back, I think Mr. Schofield has a question.
The chairman got you to state your name, but I'm not sure you ever stated your position on the bill.
I am for the bill, and I was speaking on the bill and for the bill. Because Matt's bill solves 2 problems. 1, it gets rid of the due process problem, and 2, it begins to help minimize the consequences that no fault created, so that you're not going to have continuing increases in all the areas that came out of no fault.
So you want to be listed as being for the bill?
Absolutely.
He is listed that way.
Yes.
And I said, you know, when I listened to your testimony, I guess I couldn't help but think that you think we ought to make it more difficult to get a divorce, period.
You just should go back to the fault system that worked so well. I mean, nobody came along and said to the legislature, hey, you need to go to no-fault divorce because the fault system is not working. Nobody gave that testimony. And we've seen since the problems it's created that the fault system did. All I'm saying is, hey, look, If you did from 1848 to 1970 something that served the people of Texas so well, and now you've created this monster, why not go back to it? Common sense says you go back to it.
Well, suppose we did this. And I was just thinking this based on the testimony. Suppose we did insupportability only as a consequence where it's consented to by both parties.
Nothing wrong with the parties consenting to it. No
Okay.
problem about that. The due process problem is if I have a constitutional right and you can take it from me and I have no due process, that creates a problem.
Yes.
By the way, do you realize this is the only law that's ever been passed where the defendant cannot win? You want to put that over in workers' comp? You want to put that in tort cases where the defendant can never win? Whoa! You want to put that in med-mal cases where they can't win? But this is the only one where they can't win.
I think Mr. Kane has a question.
I like that you're where you are on due process. I believe in the beginning you kind of maybe mentioned 6 elements and said there's 2 elements not present here. Could you explain those or describe them for me?
The 2 elements is that 1, you have to be able to prove a legal bar to the divorce, or 2, a lack of merit in the claim. Those are the final 2 elements of the 6 elements the Supreme Court of the United States say make up due process. The first 4 elements are all there. In other words, notice, right to have counsel, right to be able to call witnesses, right to be able to put on proof. To do 2 things. 1, either show a legal bar, which there is none, or show a lack of merit. By the way, when I handled that divorce case back sometime as a constitutional issue, I got the certificates of 175 of the 254 clerks that divorce cases were filed. From 1970 to 1993 when I handled that, they told the number of cases filed and the number of cases not dismissed for want of prosecution that went to a judgment. The plaintiff won every one. Now that is irrefutable proof that this violates, and by the way, every constitutional lawyer I've talked to, not family lawyers, they've said this is a no-brainer. Thank you very much.
Mr. Dale has a question, I think.
So has anyone ever brought a constitutional challenge to this? And?
At the end of the trial, the judge dismissed his court reporter. I had filed a brief, and the judge says, Mr. Sharpe, you're absolutely right. This thing does violate it. Opposing counsel, the petitioner, he said, Judge, I couldn't file a response because he's right. And the judge says, but I want the appellate court to tell me personally, it's unconstitutional. My client, and I was, by the way, pro bono, didn't cost him a penny, but he decided that he didn't want to carry it any further. If I could ever get somebody that would let me get into the Supreme Court of Texas with this on no fault, I know that court well enough because I've been before them a ton of times on constitutional issues. They would say it's unconstitutional. If I get before the Supreme Court of the United States, they'd knock it out in all 50 states because it's a patent thing. Nobody has got a case that supports them on the due process part of it. It's just not there.